we're ready to begin.
Sure. Good afternoon. I'm very excited to welcome all of you to the launch of Stuart Wilson's new book, Human Rights and the Transformation of Property. For many, it might seem obvious why SERI would be involved in the launch of this book. Many of you know that Stuart co-founded SERI with Jackie Dugard and was its executive director not more than 20 months ago. And most importantly, he was our chief strategist and someone who led SERI to many legal victories. But there are some less obvious reasons, and some of them probably even secret, that I'm going to disclose just now. In working with Stuart in the last 8 years, I've seen him in the courts, before 11 judges in the court. I've seen him before donors. But the one interesting thing for me has been seeing him before our client communities, and how that has been always his most anxious in the SERI boardrooms, in dusty grounds of Winnie Mandela or in Durban. But I've always questioned why that is, and almost at every meeting, I would know that it's because of the zeal that he has in translating the aspirations of our client and partner groups into implementable legal strategy and a change in their lived reality. And he earned my personal respect because he's someone who has an almost unnatural balance in his thirst for justice and the law, in his thirst for theory and practice. In fact, for me, he's someone who really responds to the words of Assata Shakur, that theory without practice is just as incomplete as practice without theory. And in having worked with him to support many communities, I've had this good fortune of having someone who understands both the theory and can articulate it in a way that is understandable to every man on the street. And I'm just thinking back to one of the experiences that I had with Tembeka about how it's so important as a lawyer to be able to explain your legal theories to an 8-year-old child who's still in primary school. And Stuart is someone who can do that. In fact, in our very first year of working together, we worked on an urgent case involving over 1,000 informal traders in the inner city of Joburg. And at the end of weeks of struggle and turmoil, I remember saying to him, you are someone who changes the law and the facts into a beautiful piece of art. For me, I gave you paint and a mural, and you gave us something beautiful and justice for those communities. But there's something that's very important about, just beyond who Stuart is, about SERI's work. This book provides a theoretical lens of the work that SERI has been doing for over 11 years. At its most sentimental, I am someone who's very, very sentimental. It is an ode to the work that SERI has been doing. But most importantly, what the book does, it gives us a framework, a theory of how we can continue to do that work until we can get to a time that all of us are comfortable that most South Africans are living the life that we all imagine they'd be living at the end of the apartheid era. And in having this launch, it is not an accident that we've lined up the people that are here. I'm grateful that in the room, the people that will speak to you include Stuart, of course, as the author of the book, Adv Tembeka Ngcukaitobi, whose name is synonymous with our reinvigorated struggle for land distribution and land reform in South Africa. It involves Professor Liebenberg, who is someone, for some of us, even in our youngest days, gave us hope that this constitution can change South Africa and give us the future that we all want. More important still, we have someone who's very important for my professional development, Lerato Marole, who's from the Slower Park Development Community Forum, which was a community from the moment that I started working at SERI, who demanded that their case be prioritized, who followed through, who knew that it is their own action that will result in development for their informal settlement. They led a community of over 10,000 people, but at every point they owned it, and they made sure that they took advantage of every space the law opened up for them in order to make sure the communities developed. But I'm even more grateful that I've asked Koketso Moeti to host and facilitate this discussion. And for people who don't know her, Koketso, she is an organic intellectual. Just like SERI, she's someone who's fixated with the agency of Black people, especially poor Black women. As a result, that she founded Amandla.mobi, which is a tool that's really available to amplify the voices of Black women and ensure they have space to mobilize and expand their own political space. She's also someone who is committed to the redistribution of wealth, which is something that is central in this book. But most importantly, I remember in conversations that I had with her last year, she spoke to me about how we're not only fighting for South Africa where people can just survive. We are fighting for South Africa where people will thrive. With those words, I'm going to hand over to Koketso, who's hosting this for us, and she will introduce the rest of the panelists more.
Thank you. Thank you for that very, very warm welcome. Good afternoon, everybody. It is a pleasure to join you. And you have just heard from Nomzamo Zondo, who is the Executive Director of the Socio-Economic Rights Institute. As she mentioned, we are gathered here to launch a book. And without wasting any time, I would like to introduce you to Advocate Tembeka Ngcukaitobi, who is a South African lawyer, a public speaker, and an author. He's the author of the best-selling book, The Land is Ours, South Africa's First Black Lawyers and the Birth of Constitutionalism. And in April 2021, he published the book, Land Matters, South Africa's Failed Land Reforms and the Road Ahead. He will just be giving us a review of the book before we begin with our discussion today. I hand over to you, Tembeka.
Yes, thank you, Koketso, and thank you to Nomzamo. I'm very pleased to have been invited here. I hold the work of SERI in high regard indeed. Myself having been at the Legal Resources Center and appreciating the complexity and the emotional taxation that the kind of work that you do places on an individual. I'm also grateful to Stuart for having written such an excellent book. And for those who do not know, I might brag at this point in time that I read the book as a manuscript. And so it was a pleasure to read it again in preparation for today. I've prepared a rather longish, it's 8 pages, sort of academic review, but I will go through it. Hopefully I won't exceed my 20 minutes that has been allocated to me. And of course, I'm pleased to speak at the same platform as Professor Liebenberg, who is someone I hold in high esteem as a person, as an academic, and as an intellectual and a thought leader in the area of socio-economic rights. Whenever you look back, it's always impossible to think about socio-economic rights theory without factoring into the matrix of analysis, the groundbreaking work of Professor Liebenberg. So indeed, it is a very great honor personally for me to be invited to speak today, and also looking at the quality and the caliber of the speakers that will come after me. Our judiciary, the South African judiciary, is sometimes hailed as a model for the world. In its short life of 27 years, it has produced acclaimed judgments spanning topics such as socio-economic rights, executive and legislative accountability, and civil and political rights. It has, particularly more recently, withstood vicious attacks from politicians and disgruntled litigants alike. Yet it remains a beacon of hope for the future, which is based on the rule of law and constitutionalism. It was in fact Nelson Mandela himself who bequeathed this function, the function of guarantor of our constitutional democracy, to the judiciary. On the 14th of February 1995, Mandela declared that the future of our democracy hinges upon the Constitutional Court. So far, our judiciary has fulfilled Mandela's wish. What is remarkable, however, about the post-apartheid judiciary is that the judicial history which it inherited is a largely discredited one. Can we therefore discuss an emancipatory project of adjudication without confronting this past? A departure point is to recognize the complicity of the judicial branch in ways of colonial and apartheid conquest. Through the system of precedent, judicial pronouncements constitute binding legal statements which must be obeyed, including by political organs who are elected in a democratic fashion with wide political support. During the age of parliamentary sovereignty, this did not matter too much. Judicial statements could simply be overturned by legislation, which was viewed as a better reflection of the views of the majority of the people. Yet, if the ruling elite was as corrupt as the apartheid state was, the laws of apartheid tended to reflect that corruption embedded in the political age. One always, therefore, looked at the judges as the counterpoint to the possible corruption of the law by the legislature. And here I don't mean that law was simply a pretense of the desires or the wishes of the ruling elite. Those understandings of the law, as Stuart Wilson points out, are often attributed to Marxist understandings of the role of law in society, which posits that the substructure of society is economics and everything else, including the law, is a superstructure determined by the interests of those who wield economic power. Those explanations are no longer adequate to explain the role of law in society. In his study, Whigs and Hunters, on the origin of the Black Act, published in 1975, the British historian E.P. Thompson criticized the Black Act of 1773 in England as a bad law drawn by bad legislators and enlarged by interpretations of bad judges. Yet his thesis was that the Black Act, a statute of the British Parliament which sanctioned by death the crimes of poaching and cutting of trees, was intended to protect the interests of the land-owning elite class against the landless. It was the landless who hunted, often in conflict with the interests of the landowners. Thompson showed that the law was used as a class instrument in the hands of the land-owning elite. Yet, and here is the paradox, he would refuse to perceive the law as no more than a pale reflection of the desires of the ruling class. In the final chapter of his book, comprising a mere 11 pages, Thompson produced a strong defense for the rule of law, describing it as an unqualified public good. But how would this be so? Thompson focused on how the formal law, camouflaged as justice, came to displace traditional norms of justice against the interests of the persons on whom it was imposed. Yet at the same time, this law constrained the powers of its sponsors, the ruling elites. Therefore, we can conclude that the law resists capture into a single norm. To understand the full impact of the law and the role of judges in legal interpretation, we must recognize its shifting uses between the hegemonic and the non-hegemonic forces. It is this unique attribute of the law that has endeared it to the colonizers and the colonized alike. It promises neutrality, treating everybody alike. The promise that one's race, gender, class, social origin, ethnicity count for nothing is a deeply attractive feature of the law. So we should take Thompson seriously. accounts of the law which situate the law in grand political narratives do not have to subordinate law into politics. Yes, the rule of law is intertwined with the political and economic systems of government, but this need not be a hierarchical relationship. The rule of law, Stuart Wilson points out, needs no preconditions to thrive, although it usually flourishes in democratic systems where political power is contested and the principle of equality before the law is observed, but not always. In South Africa then, which is a relatively new political entity created only in 1910, how should we understand the uses of the law today? I suggest that we should start by looking at the past in order to think about the future. In the years between 1910 and 1920, which constituted the institutionalization of the racial order, entailing a fundamental transformation of all aspects of society, reflective of the prejudices of the influential leaders of the day. The key institution that legitimated the racial political order was the institution of the law through the common law. Notions of private property, race, citizenship, and relationship of individuals to land were among the most important aspects in which colonial mindsets played out. We often assume that the judges of the colonial and apartheid era applied the law as inherited from Europe, but this was not always so. Significant adjustments to property laws were made to fit the conditions, for instance, of the Cape Colony. It was, for instance, not the law or the common law of England or Holland that private property rights would trump the rights of the state to act in the broader public interest. These were ideas played out in the colonies. But moreover, instances of dispossession legitimated by law illustrated the absurd outcomes of colonial conquest and the apology of law in conquest. Take, for instance, the 1875 dispute in the diamond fields of Kimberley. This is a dispute not about diamonds, but about land. At issue was who owned the land where the diamonds were found. Whoever owned the land, the principle applied, would also own the diamonds. There were various potential claimants, the Afrikaners from the two Boer republics of Transvaal and the Free State, the diamond diggers, of course, their primary leader having been Cecil John Rhodes himself, the Griquas, who based their claim on prior occupation. Their argument was that they had occupied the land before the Boers arrived, before the diamond diggers arrived. Yet, the judge who was appointed to hear the matter, Andres Stockenstrom, disputed the claim of the Griquas. The basis for the reasoning, reflective of the colonial attitudes, was that the Griquas were a nomadic people. The jurisdiction of their chiefs, he claimed, was over people, not over land. And his findings, therefore, were significant, quite more than the mere refusal to the claim. It was the transformation of the notion of ownership. He claims that because private property ownership was not recognized among the Africans, ownership in its entirety was not recognized at all. This indeed was the same justification that was used to deprive the Swazis of their land in a case known as Sobuza II versus Alistair M. Miller, decided in 1926, where the Privy Council concluded that the notion of private individual ownership is foreign to native ideas. Land belongs to the community and not to the individual. The title of the native community generally takes the form of a usufructuary right, a mere qualification of a burden on the radical or final title of whoever is sovereign. So the land belongs to the sovereign, not to the natives. It is this context then that law today must contend with. Law constructed the ideas of race, It constructed the relationships between individuals and property. It constructed the relationship between individuals and land. And it radically ruptured ideas of African land ownership. How do we deal with this? This is where Stuart's book is important, as contributing to the larger redemptive project of constitutionalism. The Constitution was meant to make us better, to lead us into a new society underpinned by new values. It was meant to redeem us from our evil past. Yet, without disrupting that past, its very promise was not only constrained, but scuttled from the beginning. In chapter 2, Stuart perceptively notes that the Constitution did not itself change the social and economic relations which it inherited. But it is, quote, a statement of faith in the capacity of law and legal forms to bring about social change. He notes that the Constitution itself did not directly interfere with the distribution of land and property rights at its inception. Its effect was, in fact, to respect existing property rights, but to leave room for reforms of property law that might lead to redistribution of property rights through statutory reforms. Most of us, and I include myself, as constitutionalists, are constantly being asked, constantly being goaded, constantly being questioned about where the transformative elements of constitutionalism are to be located. Stuart does not ask how much the legislature has performed. Rather, he devotes a substantial part of his book on the role of the judges, the judiciary, and the courts, and the impact of their jurisprudence in the changing of social and economic relations. Legal realists often argue that courts are unable to influence social change. Stuart challenges the notion. He adopts a programmatic approach to the analysis of the impact of law on social change. He accepts the ambiguity and the tentativeness of the constitutional text, as he argues that when the Constitution is applied and interpreted, it produces outcomes such as evictions leading to homelessness are not permitted. Landlords must demonstrate that the termination of residential leases should be fair in all instances, that a bank has to demonstrate that executing against a person's home is fair and proportionate. He points out quite correctly that when the Constitution was adopted, it would have been impossible to predict that these would be the outcomes it would produce. But over time, the changes in the conception of the text of the Constitution and in how it confronts the social and economic relations, its broad purposes and open textured provisions are beginning to gain ground. Of course, none of these instances I've highlighted above are distributive in themselves. They don't result in the passage of property from owner A to owner B. But this is not a ground to be despondent about the law. What Stuart illustrates is that these judgments, what they have done is to, quote, alter the existing law-governed distribution of power in basic economic relationships, which are fundamental to the property law regime. So they have changed the relationship between the owner and occupier, between the landlord and the tenant, between the debtor and the creditor. And the consequence of this fundamental restructuring of those relationships of power is to enhance the position of the weaker party in each of those relationships by providing some protection against coercive action by the more powerful party. In this way, then, I think the Constitution has opened personal agency for persons who would otherwise not have been able to exercise it had it been left to the vagaries of economic and social power or the vagaries of an unbridled market. The defenders of the common law often point to its inherently equitable foundations. Stuart, however, shows that according to its logic, perhaps illogic, one person's ownership of land necessarily implies another's dispossession. This is a topic I have explored in the context of communal ownership in the comparison between African forms of tenure and European forms of tenure. Wilson points out that the common law does not balance the social consequences of the dispossession against the rights and privileges of ownership. But as I suggested above, constitutionalism may also require us to ask whether the laws of England and Holland in fact countenanced the conduct of white settlers in settler colonies. Stuart's approach to land reform is a much more optimistic than I have been. That, of course, is because we are not looking at the same thing. Stuart argues that the statistics only tell us about the redistribution of traditional property rights. Yet his book shows that it is necessary to look beyond the statistics. It is necessary to look at the power relationships encoded in property law and how these relationships have been altered through tenure reform and through reforms to the deliberative processes through which property rights are characterized in the abstract, determined in the concrete, and implemented in practice. He argues that if we add this dimension to the picture, then a much more optimistic assessment of land reform in the post-apartheid South Africa is possible. If I return then to where I started, at the risk of giving away the entire book, how should we think about the transformation of property rights? I think this is a broad topic which at least must include the reimagination of the past and the futures of the law, the recognition of the complicity of the law in colonial conquests, and yet the recognition of the potentiality of law as an instrument, not so much of transformation, but of liberation, of complete freedom, of the negation of the present. These may appear to be in conflict, but they may not necessarily present irreconcilable conflictual premises. There can be points of intersection, sometimes points of collision, but often points of overlaps. No clear lines can be drawn between the past, perhaps the pasts, the present, and the futures. William Faulkner is right when he suggests in the novel Requiem for a Nun, published in 1951, that the past is not dead. In fact, it is not even past. So the project of constitutionalism shines a spotlight to the inarticulate premises of the law, which perpetuate superiority, cultural and otherwise. And this is not an abstract point either. We see this in our own conceptions of the law of property, which entrenches the distinction between the public and the private, but never speaks of the family, never speaks of the communal forms of land ownership. Yet these forms of land holding, even if it's not ownership, are not only pervasive among Africans, they have been practiced for generations with no legal recognition. So the larger point that Stuart makes is that the constitutional project opens a new and perhaps blank canvas for new thinking. By recognizing that the canvas is blank, we can start the imagination of what has to be written into the canvas. Thank you.
Thank you very, very much for those thoughts. A lot to think about, and you did not give away the book. If anything, those insights made me even more excited about the book, and I hope the audience feels the same way too. Now, without wasting any time, I want to move us on to our discussion. We have three wonderful people who are joining us for this discussion. Even though Nomzamo had introduced them initially, just to remind you who they are. Joining us, we have Stuart Wilson. Advocate Stuart Wilson is SERI's co-founder and former executive director. He's currently a practicing advocate, a member of the Johannesburg Bar, and a member of Thulamela Chambers. Prior to joining the bar in SERI, he ran the litigation unit at the Center for Applied Legal Studies. We also have Lerato Marole, who's a community leader and the deputy chairperson of the Slovo Park Community Development Forum. He has been at the forefront of Slovo Park's struggle for development for many, many years now. We also have Sandra Liebenberg. Professor Sandra Liebenberg is H.F. Oppenheimer Chair in Human Rights Law and Distinguished Professor in the Faculty of Law at the University of Stellenbosch. She previously served as the chair of the Technical Committee advising the Constitutional Assembly on drafting the Bill of Rights in the Constitution of South Africa, and is a former member and vice chair of the UN Committee on Economic, Social, and Cultural Rights. She's currently extraordinary professor at the University of Free State Center for Human Rights. Thank you all so much for giving us your time and joining us for this discussion, which I have no doubt will be exceptional. Stuart, I want to start with you. As we know, SERI is hosting this launch as the content of the book relates to one of the key thematic areas in which the organization works, securing a home. Before we dive deeper into the contents of the book, I'd like to understand how the constitutional and common laws referred to in the book relate to securing a home.
Well, thank you very much, Koketso, and thank you to everybody who's come and see the come to see the book being launched. I feel awkward and humbled and grateful and all sorts of other things. And I'm particularly grateful to Tembeka for his engagement with the book, and listened with rapture and interest to his presentation. To answer your question, Koketso, the stumbling block, the obstacle, the rabbit-proof fence that SERI continually came up against in its early years in its work securing a home was the common law concept of ownership. This bizarre idea that we can parcel the world off into exclusive domains in which one person is God and everybody else is subjected to their every whim. And that really is what is at the heart of our common law of property, the idea that one can do what one wishes with one's own property, one's own land, for example, to the exclusion of all other legitimate social interests in it. Now, of course, those that rule, that power, tends to be qualified in different places at different times and for different purposes. But when SERI was representing the needs, continues to represent the needs of very poor people living unlawfully on land because they have nowhere else to go, we were constantly met with the assertion that the land has an owner, the owner doesn't want the occupiers there, and that's all there is to be said. And if you adopt a completely common law attitude to things, as many practicing lawyers and legal academics still do, that is all there is to be said. One person's ownership is necessarily another's dispossession. One person's claim to absolute power over land excludes all other people's claims to the social uses of the land. But the Constitution says something different. It says that you have to balance ownership rights against other legitimate needs. And across a series of cases, many of which SERI and the Legal Resources Center, Lawyers for Human Rights, and Tembeka and I have been involved, what we've sought to do is nibble at the edges of ownership, create limitations on ownership rights in favor of the pressing social needs of the poor and the dispossessed, not only through anti-eviction cases, but through cases on behalf of tenants who stand to be evicted for non-payment of rent, or sometimes just for organizing other tenants to secure better conditions in their buildings. And on behalf of people who find their homes and their property taken away from them because they can't pay their debts. In each of those cases, we've sought to challenge the common law logic. We've sought to challenge the assertions of power, the hierarchies that lie at the center of the common law with the new emancipatory language and purpose of the Constitution. And that's really what this book is about. It really is on one level all about SERI, and therefore not just about my work, but about SERI's clients, SERI's employees, SERI's donors and supporters, and the network of human rights organizations that SERI is a part of. And it seeks to provide some sort of theoretical underpinning for what SERI and others have been doing in the last 10 to 20 years.
Thank you so much. And I definitely appreciate what you are saying about collective good, and how it's pitted against the individual good, which is something that can apply way beyond property law, just your response as you've given it. I want to turn over to you, Lerato. In 1994, Slovo Park residents were earmarked for inclusion in a housing project, something that didn't materialize. I'd like to hear from you about what were the consequences for the community of this not happening.
Yeah, thanks. I think Koketso, one is that, remember, the people that are resigning informal settlements are people that are not legally wise at most. And as and when anyone comes and deliver a promise, they believe that nothing would ever happen going forward, irrespective of commitments, whether they even went online or newspapers as per commitments to happen. But when your last hope is within the very same person that makes 100 promises without any completion of any of those promises, you keep on going back to this very same person, because you can't move anywhere without this particular individual. So community would at most be devastated, but they would still have no choice but to go back to the very same office and say, we know you promised us in 1994 or 1995 electricity in Slovo Park. And we know in 1998, you said you are going to have 2,500 households there. You even went as far as announcing it, even on the Gazette. We know you have made so many promises all along, and we still believe that we can mend things and change things better. Things only changed when young people like myself and the late Mohau, Naledi, and Dan and others then came in to realize that, yes, we've got a wonderful story to tell as a community. We've got promises that were made to us, and worse of it, in our tenure now, there were even now threats of removal of ourselves there. There was now going to be an eviction of some sort to take us about 11 kilometers away. We then felt that now it's time we take the legal route, which would then be the last hope, because the elderly had always had the political hope in regard to the solution of this particular problem that we all inherited. So we thought, even when we came to the legal part, we thought it's something that would take us 3 months, then we are done. You see, we would get the results and have houses, live normal like other people. And I can tell you, it's 15 years now on this struggle of Slovo Park. So we then started to realize that really legally, the legal part can always be a solution to some of the challenges that we are faced with. Remember, land on its own dignifies a human. Without land ownership, you are nothing. You are like non-human in this planet that we are living in. So So if one can go as far as having a shack as a shelter, it means one wants to feel dignified and have shelter upon himself. So we realized only when we got to SERI that it's a long journey to prepare things legally, to try and be specific around what need to happen, what do you want, and how should it happen. With, you know, we were blessed in that we had this legality in us by birth, that we have the right to can contest anything, even if it means any individual, irrespective of politics or whatsoever, would get what we want and prevent that eviction from happening. So the case preparation on its own took us about 4 years. It was very, very hectic. As Nonzam was saying, we sometimes had to remember people in informal settlement, we are at most taking our frustration at freeways and all this other doing toys and all that. But we then decided that we are going to cease from that, but put pressure on Nonzam and Stuart to start pushing things from our side. So we pushed, you know, it's politics are very frustrating to the needy. It's a very, very touching matter. In a sense that we won the case in 2016. Immediately when we won the case, remember the government was so ready previously to implement the actual development in Slovo. But after the judgment, we then realized that they were never ready. They knew nothing. They understood nothing. And it's a challenge and that we have inherited as a country, that we are not unpacking documents and policies, acts, the way they are supposed to be unpacked. We don't understand them thoroughly, and we are not talking to each other. So we are now 4 years, heading for the 5th year after the judgment. Whilst we are still in engagement in trying to assist government to implement the actual judgment. In a sense, they did not practically understand what needs to happen, when, how. We then have to come in and say, this is how we think this can be done. Let's collaborate together from national to municipalities in trying to unlock the backlog of land ownership and upgrading of informal settlements. So it's very frustrating, as in when it was frustrating then, before the judgment. It's worse now that when you get a judgment, the judgment says in a year, 6 months, implementation must have happened, and you are 4 or 5 years down the line, you only have electricity. See,
Yeah.
a child that was born in 1990 in Slovo Park only felt how load shedding felt in last year.
Yeah.
Took him so many years for one to feel that particular moment. Yeah.
I can definitely get your sense of frustration. Thank you so much for that. There's a lot to pick up after that from that response. But before we do that, I want to turn to you, Sandra. Just Lerato mentioned dignity. In your own work, you often center the importance of the values of human dignity, equality, and freedom in guiding the actions of both the state and private actors. Can you give me some examples as it relates to property where this has not happened and the consequences thereof?
Great, thanks so much, Koketso, and good evening to everyone. It is such an honor to be here with all of you, with Tembeka, Lerato, Nomzamo, Stuart, and everyone that is participating to celebrate Stuart's book. So just to say that I think, you know, Lerato has so powerfully highlighted dignity and its relevance to those who are homeless, landless, who don't have electricity, who are basically at the mercy of a state bureaucracy that tends to be very unresponsive to poor people and has to navigate these complexities of the law. And I think what Stuart's book does so well is it really sketches how the common law system, which Tembeka also discusses in his opening remarks, which privileges a particular concept of ownership right, ignoring the dignity of indigenous land systems, ignoring the dispossessed, ignoring the needs of the homeless, but simply based on the strict idea that the owner is all-powerful and can exclude those with lesser rights or with no rights, and how this facilitated the colonial and apartheid project of dispossession of land and assets like cattle, which Tembeka's latest book, Land Matters, also sketches so powerfully. And I think what Stuart's book does, Koketso, is he charts in his case studies this shift that has taken place under our constitutional dispossession, where there's been this move from this all-powerful property right to a more values-based system where the court is more attuned to the historical background of property rights and the current social needs, and basically chips away and reconfigures this all-powerful edifice of property rights. As Tembeka pointed out, it doesn't lead to a complete redistribution of property, but it opens up these spaces in which ordinary people and social movements can basically push and mobilize for more far-reaching reforms and eventually the total emancipation of society. So I think the values of the Constitution, human dignity, equality, and freedom are really at the core of reimagining property rights, not only for the redistribution imperative of our society, but also this global challenge that we all face in an age of climate crisis and environmental degradation is how we as a species relate to the land, relate to the natural resources of our land, and to basically reimagine property rights. And I think this book of Stuart gives us many insights into how the law can play a very important role in reconfiguring property. So thanks for that question.
Fascinating response. And I want to turn it back to you, Stuart, right? The words reconfiguring and reimagination have been used quite a bit in this discussion, you know, to describe what you're doing with the book. So in the book, you not only state, but you make a case for your claim that law brings about social change by altering relationships between agents with unequal power. Something that has been described by others in this period that we've been here. So I just want you to share briefly with the audience how you came about to that conclusion.
Thanks, Koketso. The conclusion really emerged from watching how SERI's work with the communities that we represented either promoted or tended to channel individual agency. If one takes Slovo Park as an example, when Slovo Park and SERI first engaged, the official response to the people who were living at Slovo Park is that they just weren't people. They weren't seen, they weren't part of the state's plans. Why weren't they part of the state's plans? Well, because the state didn't own enough land in and around Slovo Park in order to provide the residents of Slovo Park with the upgrade they wanted. So there was this disjuncture between the rallies that would be held every 5 years before a local government election or a national election, where the people of Slovo Park would be promised an informal settlement upgrade where they were, and what the state's plans actually were, which was to evict and relocate everybody in Slovo Park 11 kilometers further away from the urban core. And the reason why there was that disjuncture is that even though state policy said people have to be upgraded where they are, the law of economics and ownership was that the state can't do anything like that unless it owns the land. And if the state doesn't own the land that informal settlements sit on, then tough luck for the informal settlers. And that disjuncture, the way that the common law undercut the aspirations and agency of people in Slovo Park, and even placed the state under what were fairly self-imposed limitations about what it would do for the people in Slovo Park, was at the center of what I was thinking about when I started to write this book. And when I started to look at what was really going on when the state's development plans for Slovo Park were challenged, when we went to court and we said, well, you can't evict and relocate these people because national housing policy says you can't. The people who are living in Slovo Park don't want to be evicted and relocated, and you've been promising them for 20 years that you're going to upgrade them where they are. What Slovo Park and the legal team and the law and the courts and to some extent Parliament were all doing together was seeking to expand the boundaries of agency for people in Slovo Park, to broaden their horizons. Before we started, there was but one thing that was going to happen. They were going to be evicted and relocated. Now, even though, as Lerato so eloquently and appropriately points out, in terms of actual upgrades, even though there is electricity in Slovo Park now, and obviously subject to load shedding like the rest of us, where there wasn't before, actual upgrading has not yet been implemented. What has happened is that the boundaries of agency have been opened up. An eviction and a relocation will no longer happen. An upgrade is on the cards. How that will take place is a matter of popular choice for people who live in Slovo Park, and there is a way that they can enforce those choices and require the state, because of the case, to have regard to those choices and to implement them where there's support for them. And that really is how law brings about social change. It creates spaces in which people can choose for themselves what they want to happen to their lives. And when the law says that one person has all the power and another person has none of the power, as the common law of ownership in many cases does, then it shuts down agency. It gives one person the choice at the expense of everybody else. But where the law says that one person's needs have to be balanced against the needs of the many, or one has to work out which set of values and whose needs and whose aspirations are being promoted through a particular legal decision, then the law opens up opportunities, it opens up spaces, it gives people the space to demand more. But law in and of itself doesn't lead to that change. The people demanding the change and the people acting to bring about that change bring the change about. And that's another theme I tried to tackle in the book, that the idea that lawyers don't change anything. As much as we like to think that we do, as much as we like to think we're extremely special people, and as much as society tells us we're extremely special people, we're a very celebrated and very well-paid profession. We're not, as far as social change goes. If you want to change the world, if you want to redistribute wealth and power, if you want to increase autonomy and freedom, lawyers aren't going to do it for you. What they can do, properly instructed by people like Lerato from Slovo Park, who knows how to instruct a lawyer and knows how to get what he wants out of a lawyer. What lawyers can do is reshape rules and practices and structures to allow ordinary people to pursue their everyday agendas and their quests for justice. And that's what's happening across a range of cases about property law in this country, one of which is Slovo Park, imperfectly, incompletely, but not immeasurably, not in a way that doesn't make a difference. And it's very difficult to point to something out there that corresponds to a widened range of choices that ordinary people have, which is why the statistics don't really tell a full story about the way the Constitution has promoted land reform, because the statistics are really about how ownership rights have been redistributed, how one particularly classic and unreconstructed colonial idea of a relationship with land has been redistributed from one person to another. So what the book tries to do is suggest how we can start looking at how legal decisions and reasonable and legal principles broaden or narrow the range of choices available to ordinary people, and whose choices they broaden and narrow. Do they broaden or narrow the choices of very, very rich people who already have a lot of power, or do they broaden or narrow the choices of poor people who don't have the resources and power? That's very difficult to sort of pin down empirically, but it is where the action is in the law, I think. How law promotes or retards agency. And across a range of cases, the Constitution has a lot to say about whose agency matters and why it should matter and how it matters and what can be done with it.
Thank you. Thank you for that comprehensive response. Just to everybody who has joined us, a reminder that we are approaching Q&A time, and all of the wonderful panelists that we have here will be available to take your questions. So please feel free to use the Q&A portion to pose your questions. Okay, I'm going to come back to you, Lerato, right now. Stuart has referenced Slovo Park quite a bit. And in your initial remarks, you had given us a sense of, what was going on, the matter of the case. So what everybody knows is that for almost 20 years, the Slovo Park community was promised access to formal services and housing at the settlement. And then a struggle was undertaken against relocation. That subsequently became relocation, and also for upgrading of the settlement. Can you just tell us a little bit about the tactics that were undertaken by the community before approaching the courts, as well as after approaching the courts? Lerato?
Yeah, thanks. Okay, so you see, what we believed in was an inheritance of some sort, in saying the leadership before us had a belief in saying, let's have this engagement politically and outside politics with government, of course. So we then pushed from there. Our strategy was, one, let's go as far as the president, which was then President Mbeki then. Let's start there, go to the president's office in Pretoria, take the whole community there to try and make him understand how is the situation, what is what. We went as far as to the house. We went as each and every government offices, from municipal to national, trying to engage, of course, politically and official, which still did not unlock the challenges that we were faced with. Hence, I was saying politics at times are cruelty to the poor. At most, politicians would would come to the needy for benefit of in terms of elections. Afterwards, they treat the poor as like people that are brain damaged. There's no visit, there are no developments, there's nothing. Hence, you would see frustrations of people closing freeways near them, causing all these kind of problems because there are so many challenges with informal settlement. So we then had to change strategies after all these avenues that we have exhausted in saying these are things that we have done, and no one is saying no. Everyone would give you the belief that really in 6 months things will start happening. Come 6 months, nothing happens, and they would then strategically, when there is a movement, change an official that is responsible for your actual project or for your actual settlement, in saying, Mr. So and so has been moved to a different department. Somebody new must then come, and this particular individual will then have to start afresh in trying to unlock the discussions that you thought were at 90%. You're starting at 0. So you then realize, no, these strategies really are not working for us. We then decided to formulate ourselves as a community, because we felt that the understanding that I had as a leader might not automatically be an understanding of a normal community member in regard to frustrations and developments, in regard to meetings and movements around what is happening. We then decided to restructure ourselves as a community in saying, instead of us being a leadership of 15 people, let's move to as far as 280, 300 leaders. That some would lead at block levels. We would break Slovo Park into pieces so that everyone becomes a leader and information goes faster to the community. That comes from us, or challenges from community comes faster to ourselves. So we try to retrain ourselves and make sure that everyone understands what we want to achieve, how do we want to achieve it. We use one strategy, and this particular strategy would be our actual penetration towards the unlocking of development. Hence, before we even came to SERI, we went to Law Research Center. And I can tell you, within 3 months, you could see Law Research Center are taking their fees. So luckily, with Stuart and Nomzamo, well, when we pushed them around, we could see they are moving. So we basically impose ourselves to SERI by force and saying, no, we want this, and they were willing to work. And we are so happy with work that has been done by SERI in Slovo Park. Of course, they with our assistant and in conjunction with the whole community. We regard them as family in Slovo. But as per strategies, it's that even now, as we speak, most informal settlements are saying to Slovo Park, leaders, come, give us what you did different from us. One, it's do away with political differences within yourselves, because obvious politics will always divide us in saying one is aligned there, one is aligned elsewhere. So we now need to move away from politics in our gatherings and become activists of our liberation. That number one, that unites the community in seeing each other as one common community. Two, try to, because people like power, try to have as much members of the leadership as possible so that everyone can have an input in regard to the development or the views that one wants to see happening in that particular community. so that you will limit contestations amongst yourselves. That will then derail the process. Because remember, you see, SERI even realized when we were at all times saying government on its own can be the one that becomes a distraction once you are organized. They go there, create their own leadership within the settlement. Whereas there is leadership that has been elected by the total community. Then becomes a contestation now in regard to discussions as frustration, as a way of frustrating you and derailing and buying time in regard to implementing what needs to happen. But all in all, outside these particular strategies, we also realize that a government official does not necessarily understand what needs to happen. Remember, there is no practical school of development. All other fields may have practicalities after varsity. This one does not have. One has to go straight to the field. And one thing that one must understand is that these individuals at most comes to informal settlement as not only people that are going to assist you, but they come as superiors and officials and would not want to listen to somebody like myself that is not even that not even have a matric. You see, he would not want to listen to somebody that resides in a shack. It's his way or the highway. But element that one misses out that derails the upgrading of informal settlements, it's the development of the people by the people. Without them, there is nothing that can come forth. Without engaging them, there is nothing that can come to perfection, in a sense that you do not understand specifically what did people need at that particular time, what need to start first, how it should supposed to be done, and all these elements. So in ourselves, as I'm saying, in us, we've always had this element where we're saying we want this development in this particular way, and we are going to have it in that particular sense. I can tell you, for example, immediately after the judgment, to show that there was no understanding of what needs to happen, government then said we are going to build 399 houses without not even understanding or knowing as to whether who are these people residing there, how many are they, how do I go about this particular. So they are dealing with a blanket approach in regard to the whole settlement, and whoever will go into these 399 households, the rest will remain. Then they would have dealt with the judgment, they are moving on. But we then said, no, it's not how it's done. Let's start first by going down and do a socio-economic study to understand who are these people, who's working, who's not working, what is happening with this particular individual. Then you plan for development. You're planning for people that will understand what surrounds them at that particular time. So we are still learning even today. And I so feel and hope that we would have from government. I always mention this, that we need to have champions of informal settlements upgrading. That can only be a solution to us upgrading these informal settlements. Otherwise, for as long as we still have people that were there in 1994, 1996, 97, that are used to greenfield development, they would never integrate to this new way of doing things. In the new normal that we have to integrate to and have mask at all times, some are struggling to integrate to those particular new ways of doing things, which is an upgrading of informal settlements, not eradication of those informal settlements. And in an UASP manner where engagement of the community and parties involved, it's a priority of all things. I thank you.
Thank you. Thank you so much for that. The clarity of purpose and the centralized collective leadership are big components that I'm taking away with me. There's questions in the chat, but before I go to the questions, I just want to ask you something quickly, Sandra. In the previous two responses, right, agency has come up quite, that seems to be the recurring theme. And you often refer to the importance of the state acknowledging people's agency, that people should have meaningful opportunities to participate in decisions impacting their lives. What do you think that looks like in practice in relation to property? I know that this is a very big question, but I have no doubt that you can give us some insights into your thoughts in limited time.
Thanks, Koketso. Yeah, thanks for a great question, but also, as you say, a big question. So I think, you know, thinking about Stuart's very rich concept of spaces and agency in the law, what he also highlights in the book is, you know, the kind of support structures that one needs to make that agency sort of work effectively, to prize open those spaces, you know, and to push the games further. And just listening to Lerato and to Stuart, there's just, you know, three areas that I would like to highlight, you know, that I think are important in this area. I mean, the first one, I think, you know, is the question which Lerato highlighted so much around the public administration and effective governance. You know, a lot of the problems being experienced in informal settlement upgrading with turnover of local officials and, you know, people that aren't sympathetic. And, you know, we focus a lot on legislation, policy, and the courts, but I think also the need to focus on effective governance and administration so that, you know, court orders don't end up being empty, and that we also look at how we can infuse a kind of rights consciousness in the public administration so that, you know, for example, you know, you can have effective implementation of land restitution and, you know, school feeding schemes, etc., etc. So I think that is one important area to support agency. The second, I will just briefly highlight, and, you know, I was very pleased to see that Carl Clare is also part of this discussion, and I know he'll be embarrassed by me mentioning him, but I think his article, his very prescient article that he wrote, you know, over 20 years ago on legal culture is still so important that I think many lawyers and judges are still far too restrained and conservative in pushing forward the full transformative potential of our constitution, and this restrains what can be achieved. And I think this really speaks to legal education, how we educate the lawyers of today. So it's not about putting, you know, new wine into old skins, and we use the old methods and the old paradigms of, you know, the British systems of separation of powers or the common law tradition. So this seems to be another important area. And then just lastly, which was very vividly demonstrated by Lerato's comments, is you need that movement building and the social movements, and yes, individual ordinary people acting, but also people acting collectively and together, and being able to capacitate and build social movements that can take forward struggles over time. So, you know, to push the gains that have been made in property rights further to a more fundamental transformation of our property areas. So I would just like to highlight those three areas that are needed to support agency. Thanks, Koketso.
Thank you so much for that. I am turning over to the chat where there's been a couple of questions that have been posed. Stuart, I'm going to begin with 2 questions from Sibusiso Khadebe. The first question being, what are, oh, fancy, we are sharing screens now. In relation to the gains so far, especially around the limitations of lawfare and socioeconomic litigation space versus political will, what strategies have been effective to tilt the scales in favor of the poor and marginalized? And the second question, I'm reading them for the benefit of those who may not be able to see the screen. Are the attitudes of judges changing in terms of better understanding of socioeconomic compared to, say, 5 to 10 years ago? Stuart, I'm going to hand over to you.
Thanks, Koketso. There's a whole range of strategies that have been effective. It really depends on the context in which they're deployed. What I try to draw attention to in the book are the strategies that seek to attack assumptions in the law about inequality and about power. And so if one looks at something like the Grootboom decision, where really what you have is a question about what the state must do and when it must do it for the most desperate and marginalized people in our society, people who literally have nowhere to go because they've been evicted. And you look at the outcome of the Grootboom decision, which is effectively that there is more or less, although the court was reluctant to say it in these terms, the effect of the decision is pretty much that there is a right to emergency housing on demand if the alternative would be homelessness. Now, if one thinks about that principle, a right to emergency housing on demand, a right to emergency shelter on demand if the alternative would be homelessness, that principle and the way it's implemented and how it applies across a range of different situations ripples out into pre-existing power relationships and disrupts them, particularly pre-existing power relationships about property. So if one person has the right to emergency shelter on demand, if the alternative would be homelessness, but they're living on someone else's land, what does that say about their relationship with that person? Which principle comes first, the principle of ownership or the principle of shelter for the desperate? Now, the courts have been fairly consistent, and this is what I say in the book, with some exceptions, with some setbacks, but the courts have been fairly consistent over 15, 20 years saying, well, actually, it's the rights of the poor that come first, not the rights of owners. Owners have to tolerate poor people residing on their land if the alternative would be homelessness. And so the strategy that led to the Grootboom decision, that led to the assertion of some degree of priority for people who are ordinarily treated with none, is in itself disruptive of existing power relationships in society. And I would argue has rippled out through the anti-eviction jurisprudence and significantly limited the power of owners of land in South Africa to dispossess and immiserate poor and vulnerable people. And so to answer Sibusiso's question pithily, or as pithily as I can, it's those strategies that identify a point in which law and power point, a location in which law and power point the same way, and to turn the law 180 degrees, or 5 degrees, or 10 degrees, to create tension between what the law says and what power says should happen. And that's exactly what happened in Grootboom. The claims of poor and vulnerable people were prioritized, and over time started to trump the claims of rich and powerful people. And where the law has done that, it has been its most effective. The second, and in the book I talk about how the law has done that in relationships between banks and homeowners, and relationships between landlords and tenants. in differing ways, to differing degrees of success, but the principle is the same. Are law and power pointing the same way? And what can we do to get law to point a different way? To answer the second question, are attitudes of judges changing in terms of better understanding the socio-economic and socio-economic rights compared to, say, 5 or 10 years ago? I think the picture is quite complicated. I would say overall, the understanding of constitutional law and socio-economic rights on the bench, both as somebody who sometimes sits as a judge and obviously somebody who much more frequently appears in front of them. I think things have generally become better in the sense that more progressive and imaginative judges have felt more able to take a stronger line to develop socioeconomic rights. And more conservative judges have felt more closed in when they've instinctively gone for conservative outcomes. They've had to think twice before leaping directly to those conclusions, and they've often constrained their more conservative pro-owner inclinations because they know that there are socioeconomic rights out there. There's the PI Act out there. There's ESTA. So I think things are generally getting better, but there are two points to make about the complexity of the situation. The first I won't labor because Sandy already made it. Legal education in this country is still substantially an artifact of the pre-1994 world. There are many progressive teachers of law, but there are many other teachers of law that don't seem to have yet fully abandoned or qualified the common law game. And the way lawyers are educated from the undergraduate degree right through to the professional socialization of pupillage and training as a candidate attorney leaves a lot to be desired. The old assumptions are still there. Deeply traditional ideas of the lawyer's role and of the common law itself are still assumed rather than challenged. Today's attorneys, today's advocates, today's magistrates, today's academics are tomorrow's judges. And so if we're not changing the way we teach law and how it interacts with social needs, we are not creating judges who are going to be willing to use the Constitution to its fullest transformative potential. The second point is that we still have no real deep conception of what a judge is and what a judge should be. There is no public transcript and certainly no fully explained idea amongst the people who vet, shortlist and appoint judges of what a good transformative judge is. There's a lot of debate about it, and there's a lot of richness in that debate, actually. I mean, the JSC comes in for a really hard time, I think harder than it really deserves. But I think it would be right to say there's very little coherence that you can get out of what the Judicial Services Commission says about what a good judge is, or very little coherence you could get out of watching a judicial interview. But there is a richness of debate, and you can see different commissioners and different people who are involved in the appointments process struggling with what a transformative judge is. And organizations like Judges Matter are deepening that debate. But we need to have an idea about, if we're going to start criticizing judges for not being transformative, or if we're going to push them to be more transformative, or we're going to praise transformative judges, we do need a pre-existing idea about what a good or a bad judge is. And I don't think as a society we have that.
That is very, very helpful. Thank you so much for that. SERI alumni are coming through with those questions, hey? So our next one is from Mbegezeli Benjamin. A question to Stuart, which Tembeka provoked in his remarks. Have we explored the limitation of the law and the judiciary in driving the social change in property relations? How much of the work of the judiciary has crowded out the legislatures? And what risks do you foresee in this approach? What are the chances of us seeing a fight back by property or landowners through capturing the legislative process?
Is that still a question for me?
Still a question for you, Stuart.
So,
yes.
well, I mean, yeah. So, look, Mbekazili has asked three very incisive questions in one. Have we explored the limits of what the judiciary and what the law can do? No. And if we did, the constitutional project would be over. What we've done is to scratch the very surface of the transformation that can be brought about through constitutional transformation. And the criticisms of the Constitution that it didn't magically change everything overnight are wholly unrealistic. Social change and transformation is a long-term process. And that's deeply painful because the urgency of inequality and violence in this country is palpable. And so, you know, I know what a cop-out it sounds to say, you know, constitutional transformation is a long-term project, but the fact of the matter is that it just is. It's path dependent. You do one thing with a constitutional principle, it either works or it doesn't work. And to some extent, it sort of half works. Then you have to decide what worked and what didn't work and take the next step. And so much that is disappointing about the way public interest litigation is talked about in South Africa is everybody expects the one case to solve everything. The one case will never solve everything. There needs to be a coordinated program of litigation, legal activism, community-based organization, legislative reform, and every other social change strategy you can think of, mutually reinforcing each other, and each on an iterative long-term path to bring about the redistribution of wealth and power in this country along with the constitutional vision. And in that process, I don't think the judiciary can crowd out the legislature. I don't think the legislature can crowd out the judiciary. I think all of those organs of state, all of those parts of the state and other parts of society and public protest and the whole kit and caboodle, if you like, is going to be in constant dialogue, sometimes competitive tension with each other. And so what I try to talk about in the book is if you focus on the way a particular legal change has opened up or closed down the range of choices that are available to ordinary people, you can start to see what the future of constitutional transformation will look like, because you can start to sort the kinds of legal and political strategies that have opened up agency from the kinds of legal and political strategies that have closed it down or not opened it up as much as it could have been opened up. If you can do that, you can start identifying where the next step is. And what I try to do in the book is show over 20 years what the trajectory of social change in the area of owners and unlawful occupiers, landlords and tenants, and debtors and creditors has been over the last 20 years, and tried to give a flavor of how it's path dependent in that every step depends on the opportunities opened up or closed down by the last one. But there is a coherence one can detect by looking at the cases together and the ways in which, importantly, communities and activists have responded to the cases and gone in different directions. Nobody would have thought when Grootboom was handed down that not only that an eviction that leads to homelessness would be outlawed, but that people would be able to shape their own the terms on which they were reaccommodated in an alternative accommodation given in the aftermath of an eviction. But that's happened in Dadler versus the City of Johannesburg. Nobody would have thought that it would be possible for poor and vulnerable people to move on to land because they have nowhere else to go, and then say, well, the law says if we have nowhere else to go, we can stay, and you better start thinking about an informal settlement upgrade. That's what happened in Milani. That's what happened in the Fisher case. And so from these seeds where the Constitutional Court tried desperately in Grootboom not to say that there's emergency shelter on demand, everybody knows that there is, if the alternative would be homelessness, you get these much bigger claims And the link between the little seed that the Constitutional Court planted in Grootboom and these much bigger claims is the agency and the activism of everyday people. And communities within informal settlements that are working towards implementing their agendas. And it's how those communities have exploited the different things that the courts have said that the book focuses on. And that's how law leads to social change. And in my opinion, set out in the book, I don't say that's a total opinion and it excludes all others, but that is why we haven't tested the boundaries in SERI, because the boundaries are always moving. Every time there's a new choice, every time there's a new possibility, the boundaries shift out and the Constitution can then go and test them.
Okay, thank you so much for that comprehensive response. We are going over time, but I want to ensure this is such a rich discussion, and I want to ensure that the questions that were posed are answered. So I'm going to ask you, Ed, to move us over to the next one. Our next question, which is also for you, Stuart, do you think strategic litigation can cure a lack of political will in the housing crisis or lack of formal land reform?
Can it? Yes. Does it always? No. It depends on the circumstances. So if one looks at, for example, the Slovo Park case, where strategic litigation was used to take eviction and relocation off the table and put the state in a position where it had no choice but to implement the informal settlement upgrading program, certainly the case to a certain extent, I wouldn't say cured lack of political will, but certainly made it less of an obstacle. The Slovo Park community wasn't evicted. Electricity was provided. Tenure was secured. An informal settlement upgrading plan was developed and submitted to the Provincial Minister of Housing, who's now been sitting on it for a while. And that's the next problem that the community confronts. So litigation used in that way as a club can certainly cure political will. Can it change vast ideological assumptions shared by the bureaucracy about what land reform should be and what kinds of political agendas should be pursued in aid of land reform, for example? No, probably not, except to the extent that a particular judicial pronouncement influences the sort of ideological atmosphere in which activists debate with bureaucrats, debate with politicians. So it's a very context-sensitive question and a very context-sensitive answer. It can, but it doesn't always. And there are some places where it's better at doing it than others. I'm getting shorter, Koketso, less comprehensive.
Yes, and that is amazing that you have picked up. Our next question comes from Tim Fish Hodgson. I wonder whether Stuart or any other of the speakers or panelists have views on the relevance of applying a decolonization or decolonial lens to property rights analysis in South Africa. I am happy to invite anybody else who was part of the discussion. If you feel you want to step in, please feel free to step in this response to give Stuart a bit of a breather. But if not, it will be over to you, Stuart. Sandra, I see you've unmuted yourself.
Well, I mean, I think I wasn't going to attend, but I mean, I would be interested if we could perhaps ask Tembeka to share his insights on this, which is, of course, a very lively and hot discussion. I mean, I do have thoughts on it, but I would also be interested to get Tembeka's inputs on this. So just a suggestion, but I leave it in your hands, Koketso.
You want to kick us off with your views first before I head over to Tembeka?
Yeah, I'm happy to. So, yes, I mean, I think absolutely. And I think what Tembeka was also foreshadowing in his opening remarks is, you know, how different ways, patterns of communal land ownership, of commons, of relating to land, can offer new, can help to decolonize this concept of property rights that Stuart was busy trying to unravel for us. And I think there are, you know, sort of a lot of other areas of dispute settlement and so forth that could be explored further. Of course, I mean, it is a complex and fraught issue because some scholars within this tradition would argue that the Constitution itself is, you know, as a product of the political compromise, is too shot through with colonial notions of, you know, liberalism and, you know, sort of retention of property rights and, you know, colonial structures to really, you know, be able to be used as a tool of effective emancipation in this context. So that is, of course, a very lively sort of debate in the field. But, you know, my sense is, and I think Stuart's book is also very helpful in sort of showing us how, you know, it's not the Constitution per se. I mean, the Constitution creates values, it creates institutions, but it creates spaces, but it's up to how we use and mobilize and how organizations of people use those spaces to emancipate people and to lift oppressive relationships. So I think, you know, it's a really helpful shift of perspective into how people, people's agency, as Stuart would say, and how that can be used. So that's a very convoluted response, but I hope there's a kernel of what I was attempting to get across here. Thanks, Koketso.
Thanks so much for that. And Tembeka, you have been appropriately been asked to give some input on this question. So I'm going to invite you to share with us your thoughts.
Yeah, thank you. I mean, yes, I agree with Sandra in relation to the first part of her response. I think that the problem has been that we have spoken a lot about transforming property relations, but little about transforming property itself, you know, the conception of property. And that's one of the points I try to explore in my own book, is the notion of property itself needs to be interrogated. Now, what does that look like in practice? So property as an idea is something that is Eurocentric and Western, and it is imposed in Africa during, there were three phases of conquest. There's slavery, then there is the theft of minerals, and then there's the theft of land. So it's imposed during those three phases. But its purpose is the appropriation. It's the taking on an exclusive basis. And the main theorist of property is John Locke. And that's the person who gives us the lens through which we look at the ideas of property. And what his theory basically is if you combine your own labor with what is referred to as terra nullius, in other words, you know, vacant land. You combine your labor with vacant land, it becomes yours, you own it. So it is not particularly helpful for us to speak of the transformation of property relations without transforming property itself. So what would the transformation of property look like would be to ask whether or not there are alternative lenses through which we can view the idea of property. So we know that there are several. We know that we don't look at property through family lens, yet we know that it is an entrenched way of looking at property in African context. We also know that we don't look at property through community or communal lenses, yet we know that it actually exists. In this country, 22 million South Africans live under traditional forms of political leadership. So, and the third one, which we know is an integration of all three, including, by the way, state control or state ownership. Now, unless we infuse those three elements into the private of the so-called private property, it's impossible for us to fundamentally rethink property relations. So the starting point I've argued is to see property as a contested concept. And the reason why land reform has been, one of the reasons at least why land reform has been such a failure is because our fundamental conception is still a Eurocentric. So what we want to do, we want to take private property from owner A and give it to owner B. So we take it from a white person, we give it to a black person. But what we don't do, we don't fundamentally alter the ways in which we relate to property. We don't change the actual structure of the property relationship. And it's also a little bit difficult to see how this would work, because ordinarily, if you return property that was taken after 1913, what used to happen between 1913 and 1936 is that communities, large communities, would be removed from large pieces of land. But the beneficiaries of those evictions, if I can put it that way, would be one person or two people. So what you find right now is that those communities that were evicted, maybe 50 people were evicted or 60 people. They've now grown to 500 or 1,000. And so to return, I mean, this idea of the return of the land, so to return the land to 500 people when in fact it was previously utilized by one person, and then to think about subdividing, whether it is a community property association, 500 ways. I mean, the consequences, as I'm describing, can be that absurd. But the fundamental problem is a conceptual one, which is we have not yet decolonized the idea of property. Thank you.
Thank you. Thank you. That response is deeply appreciated. I am working towards bringing us to a close, but we do have a final set of questions that I do think should be responded to. In what ways do you think that legal tools like social rights can only tinker around the edges of a political economy that further entrenches the status quo and forecloses avenues for reimagining solutions along political lines? How have the events of this month affected your thinking on this question? This question is meant for Stuart and Tembeka. I'll invite either one of you who wants to step forward to go for it.
The question invites me to make a distinction between law and political economy, and I don't accept that there is such a distinction. Political economy is created by law. Economic relations are legal relations. That's why what Tembeka just said about how the concept of ownership and the concept of European property law is one of the key impositions of colonialism, which is a view absolutely endorsed in my book and I think is irrefutable. That's why that view is so important, because it calls attention to the way that law structures the economy. So there's a distinction between whether, there's a distinction to be drawn between whether changing the laws can change political economy. Well, of course it can, because political economy is just a set of legal relations. Ownership is a central economic relationship that makes capitalism possible. In fact, capitalism developed along with property law, and each served the other's purpose. Whether lawyers and legal strategies are effective to change the laws that structure capital and political economy, I think, is another question, and it may be the question that is being asked. That is a much more difficult question to answer. I think the major limitation of lawyers and legal strategies in seeking to bring about that kind of transformation is our class position. We're very well-heeled, propertied members of the middle class, and there's only so far you can expect us as a group, no matter how enthusiastic we are, and I am very enthusiastic about social transformation, to act against class interests. And certainly, asking lawyers to change anything about a society that they fundamentally benefit from is a tall order. So to that extent, using lawyers and legal strategies to fundamentally change political economy has its limitations. But in terms of using lawyers in the broader sense, people who talk about the law, who analyze the law, who change the law, who reshape the law to change political economy, you can't do it without an understanding of the law, because political and economic relations are, to a great extent, legal relations.
Thank you. Thank you very much for that, Tembeka.
Yeah, I mean, I agree with Stuart. I mean, I just wanted to add a footnote, a historical footnote. You see, when the British arrived in this country, what they wanted to do was, of course, to impose a particular political regime, which they did by violence, but then subsequently they passed several laws. But on the economic front, what they created were, one, the law of property. The law of property is entirely Eurocentric, but that was the law. They designed a way in which the people related to tangible and intangible assets known as property. The second thing is they designed a law of contract. Even that law of contract is sometimes called commercial, but it's a way in which one related to property primarily. The third thing was they designed criminal law, and one of the offenses was the offense of occupying land, and that itself was a political thing. And then the fourth thing was the law of delict, in which one of the elements of delict was how much should you compensate for an enslaved person who loses a finger or who loses an arm, how much should they? So these four pillars of the common law are embedded in a colonial substructure. The big problem, the big challenge of constitutionalism in the post-apartheid era is how to engage, not with the legacies, but with the pervasive presence. Not the legacies sometimes obscures the pervasive presence of these constructs. So all of these, in other words, the economic relationships are legal relationships, the political relationships are legal relations. So Stuart has explained that quite powerfully. But the only point was just to make one historical footnote that one should not easily accept the artificial distinction between an economic relationship and a legal relationship. Thank you.
Thank you, and I appreciate it footnote. I am going to go to the next question before bringing us up to a close. And the question is from Lindani Mhlanga. The question, just like cultures in general, legal culture takes longer to change. This is true for the South African legal culture, a tendency that can be investigated through a notion coined continuation, in which progress is attributed to piecemeal advances, to a preconceived equality which seeks to suggest that the situation is meant to adapt to the approach as opposed to the approach adapting to the situation. Given that one clear problem in the realization of adequate housing is the lack of sufficient land or resources to acquire such land by government, vis-a-vis the demand, vis-a-vis the concentration of land in private hands on the one hand, are there any ideas that come to mind within the current constitutional framework and prevailing scheme of things in terms of how best we can go about preventing the loss, speedily restoring the human dignity and security of tenure? I accept that litigation may come after the fact. I am opening this up to all of our speakers. Whoever wants to take the question, feel free to. If not, I will be picking on you, Stuart. Nobody's stepping up. Sandra, there we go.
I'll just be brief, Koketso, and then we could give Stuart the last word on this. But I mean, I think obviously, the people wouldn't be using the courts or going to the courts if our politics delivered these speedy solutions that Lindani is calling for so correctly, you know. And I think, you know, ultimately it's a political project that, you know, we need to pursue, because, you know, it's so right what is said there, that the law is slow, it is cumbersome, it can be very alienating for people. There are not many public interest law firms. Access to justice is a very scarce resource, and, you know, changing legal culture is a long-term process. And yet, you know, if the events of the last couple of weeks have shown anything, is that, you know, the situation is urgent. You know, people's needs are absolutely key at the moment. So we do have, you know, an issue of politics and enacting the kinds of policies in land reform and housing that can bring about this kind of speedy change. But, you know, people turn to courts when the politics is unresponsive, when other avenues are blocked, and then they do try and call on the power of the law to assist them. And I think the question that Stuart's book then sort of poses to us is, how responsive is the law, are the judges, are legal doctrines to the claims of impoverished and dispossessed people when they turn to the courts. And it's within that space that we are really grappling to create a legal system that is more responsive to the claims of the poor and dispossessed. Thanks, Koketso.
Thank you so much for that, Sandra. Stuart, unless there's anything you want to add to that response, I have a final closing question for you. So shall I go ahead?
Yeah, I'll ask me your question and I'll supplement Sandy if I feel the need to, but I completely agree with everything she said.
Okay. So in closing, we are here brought together by launching this book to the audience, to all of us, you know. What is the one thing, I suppose there are many, but I want you to come up with what is the one thing you want anyone who's reading the book to take away from this, irrespective of whether they're a lawyer, whether they're part of the movement. Me, in my house, as Koketso, I read the book. What is one thing you hope I'll take out of it?
Things can change through hard work and understanding.
Nice. Very concise.
To supplement Sandy's answer, and maybe to close off as well, law is in desperate need of democratization. The legal profession, the way law is practiced, what the law says, needs to reflect South African society in all its different strands and guises in a way that it just doesn't now. Tembeka is absolutely right. The content of the law, lawyers ourselves have a colonial, racial, and class bias. So law needs democratizing. It's taken at least 350 years to get South Africa as formally democratic as it is now. The democratization of law needs to be seen in that long-term context. What I take from the last couple of weeks is simply that and Sandy says, and gender bias, and of course, and gender bias. So one of the major strands of democratization that's required in the legal profession is to remove the horrendous gender bias that we all see as well. But one needs to see the democratization of law as a task that is as complex and as long-term as the democratization of the rest of society. What the last 2 or 3 weeks say to me is that there are perhaps the vast majority of people in this country, that isn't an answer to them. That isn't you can't just turn around to them and say this is going to take time. The needs are urgent and they're now. We need to start as lawyers and as public interest lawyers and as political activists and as legal activists to give an answer that directly responds to individually expressed needs on the ground. And if we can't give that answer, then we may be endangering the future of the constitutional project itself. Not the only trigger, but one of the widely acknowledged triggers of what happened over the last 2 or 3 weeks is the termination of the COVID grant, which I've noted has now been re-implemented, and quite rightly so. If we're saying to people, this is going to take time, we're democratizing our society a step at a time, and we're not responding to urgent everyday needs like the need for people to eat through something like a basic income grant and a COVID grant. And then if we're doing worse and telling people that they can't go out and get a job because of the COVID crisis, but at the same time, we're not going to give them a grant in order to feed themselves and their families while the crisis sees itself out, that is a real danger. And that is something that we have to think quite carefully about when we think about sustaining the democratization of law and sustaining the democratization of society. Urgent needs matter. And that is exactly what has been demonstrated so amply to us over the last 2 or 3 weeks. I'd like to thank everyone for coming. I'd like to thank all the panelists for everything they've said. I'd like to, of course, encourage everybody to read the book. And I look forward to more discussions and debates with all of you about your ideas and the ideas in the book and how they intertwine. Thank you all very much.
Thank you, Stuart, for leaving us with that high note and reminding us of the urgency of what matters. I want to also congratulate you on this timely contribution. I want to thank all of you, Lerato, Sandra, and Stuart, for what has been a very rich discussion, both a bleak picture, but also so many possibilities. I want to also thank Tembeka Ngcukaitobi for joining us this evening, and so the Socio-Economic Rights Institute for bringing us together for this very important launch. Most importantly, I want to thank every single one of you who has joined us for giving your time. I hope you really enjoyed this discussion. And as Stuart has pointed out, definitely encourage you, go get the book, send him your thoughts. Thank you all so much.